Welcome to K-Talk, a special Squib cast episode for Halloween. We will be talking about the famous case of Stambovsky versus Ackley that involved a haunted house. Unfortunately, my usual co-host, Steve Maxwell, is unable to be with us, but fortunately, we do have a special guest as a co-host. We have Sir George's ghost from the Helen Ackley house in Nyack, New York. He's been scaring people away for a long time. So welcome, Sir George.
Thank you, Dan. I'm Sir George. Stay away from this property.
Oh my gosh, that's horrific. That's horrific. Wait, what's happening? Wait, what's happening? Wait, that's not Sir George. It's Steve Maxwell.
And I would have gotten away with it were it not for that meddling assistant.
Oh, yeah. Good one, Steve. But unfortunately now I think you're going to be arrested and taken away to prison. Isn't that usually the way it ends in Scooby-Doo?
I think so.
I think so. I think I get arrested now and they haul me away. Yeah. And then everybody has a laugh.
Yes, and they do. They all laugh about it. You know, it could have been, I really think they missed the opportunity to do the Law and Order thing. It could have been way ahead of their time, don't you think, than the prosecution of the guy who'd scared people away from the house.
That could be a spinoff.
It could be. Oh, Scooby-Doo, like the Law and Order, Law and Order, Scooby-Doo, whatever.
Yes, it's when they catch them.
They have so many spinoffs. I can't keep up, right? For the Special Victims Unit. Yeah, it's this. Yeah, it's
Special Scooby Unit.
The Scooby Unit. I love it. So we are today doing a special Squib cast. All Squib casts are special, though, Steve, aren't they?
Absolutely. This one has kind of haunted me for years.
It has. Yeah. See, you're really getting into the spirit of things here.
Oh, very nice. Very nice, Dan. Welcome to the club.
I'm learning from the master. Oh, so wait a second. We got to talk about this. You must love Justice Rubin. So Justice Rubin, in this opinion, says things like the plaintiff didn't have a ghost of a chance. I'm moved by the spirit of equity. He does all this stuff. My sense is you like this.
I feel like I could have written this opinion, or I could have written a concurrence or a dissent. It wouldn't matter. I would have had fun with it. But just like this majority opinion, fantastic. Well punned.
This is why, and I don't want you to take this personally. This is why, if you are ever going to be appointed to the court, I will appear to oppose your appointment to the court. So to avoid more opinions written like this, but I know a lot. I think there's probably either you really like it or you really don't. I don't mind puns. I like to make jokes myself. In the opinion, the only problem I've got with that is I think might it distract sometimes from the seriousness of actually what's going on in this case. But it really doesn't matter at the end of the day, does it?
Well, but I see the point though, and I think there's a lot of validity to it. I think where they stayed away from is putting in the puns in like the rule of law. That would have been a little bit out there. But I think this was probably some clerk fresh out of law school who I don't know who drafted some of these little puns and remarks. I particularly love Who You Gonna Call because of course I'm a huge Ghostbusters 80s fan.
And I will tell you, what I do like, and we'll talk about the Who You Gonna Call, and we're both big 80s fans. I like the Who You Gonna Call because it does actually raise an important issue of what are you going to do about this problem? This is not a defect where you can go in and just easily fix it. And so I do like that idea of who you're going to call. But all right, let's set the table here for our listeners. So today we are talking about a famous case dealing with a house that was reputedly haunted. And the seller enters into a contract with a buyer and does not disclose to the buyer, at least according to the opinion that is written, and apparently the record on appeal does not disclose to the buyer that it is haunted before entering into the contract. And the question is whether or not the contract can be rescinded, undone, because the buyer learns about it after entering into the contract and then wants out. And this was a house in Nyack, New York, which, as I understand, takes Halloween quite seriously. I think they have a good time on Halloween. I don't know if that's simply because of the house. There's this house owned by Helen Ackley, and she has taken advantage, in fact, of her belief that it's haunted by she submits an article to Reader's Digest where she talks about the various experiences that she's had. And it is also included on a walking tour of haunted houses in Nyack, New York. And we know these are very popular now, and people love to walk around and hear ghost stories. And it was on one of these tours. So she had taken advantage in a certain respect of the fact that it was repeatedly haunted. As just to mention, so I pulled up, I used to have a copy of the Reader's Digest article. I searched for it, I couldn't find it, but Wikipedia lists some of the things that were in the Reader's Digest article. And so let me just mention some of the things that Helen Ackley claimed about the house. She said that this one to me. So she says she's painting and there is this apparition watching her. And after the fact, apparently people came in and did some research and concluded they think it's maybe was this guy named Sir George and Lady Margaret was this couple who had lived in the house in Revolutionary War days. And then you're going to see there's a third ghost that appears, and they think that he is some sort of Revolutionary War lieutenant. So Sir George, so she doesn't know Sir George at the time. Sir George is watching her paint in the ceiling. He's in midair. He's rocking back and forth. She's on a step ladder. She asks, "Do you approve of what we're doing to the house?" Because I guess that would be kind of troubling, right? I mean, you're painting, you're redoing stuff. I assume you want to make it's okay with the local resident. And he says, yes, as the colors are to his liking. He smiles. He doesn't say yes. No, I'm sorry. He smiles and he nods. This is the one that I think is most interesting. Helen's daughter, Cynthia, reported that when she was young, she would be woken in the mornings by one of the spirits shaking her bed for school to get her up for school. This to me is amazing. I remember when my daughter was young, having to go in there and, go in there like 9 times. Are you up? Are you up? Are you up? We got to go. I would always be racing down the road. It's like I'm driving recklessly with a small child. So I get her to school on time. It was a weird balancing of interests to get her there. This ghost would wake up Cynthia. And the best one is, Steve, is it was Christmas holiday and the ghost was waking her and she's angry at the ghost. She said, "Let me sleep in. There's no school." And it stopped. The shaking of the bed stopped. He let her sleep in. So, and footsteps and the slamming doors. Apparently they were gifted items would appear and then they would disappear. And then Helen says that she comes, quote, eyeball to eyeball with the figure of a Revolutionary Navy lieutenant. I don't know if she's just good at insignia. And she's like, "Oh, you're a lieutenant."
Right.
I don't know.
That's very precise. Maybe she's a Revolutionary War buff or something.
Indeed. And she knows. And so that's what's been happening. And then she enters into this contract, and the buyer is not a local. The buyer is from New York City. And,
New York City.
Isn't that a commercial, right? Or something like
yeah, it's some hot sauce.
Yes, he's from New York City. And what is, ghost? You see a ghost, New York City. A ghost is like the worst of your problems, at least your problems, right? That sounds great.
Right. The New York City ghosts don't stop shaking the bed. They just don't care. They'll keep shaking.
They just walk by you.
Right.
They're on the subway. No one's, except for Ghostbusters. That's why it was so serious, right? In Ghostbusters, this is so unusual for the ghosts to do activities like that, right? Like scare you in a library. They usually they just leave you alone. And so we've got a lawsuit then when the buyer learns about this. And the question is, should the buyer be able to rescind this contract based upon the seller's duty to disclose? This actually, I think it's an important case. I used to teach it, but one of the problems I had was it's so entertaining. I love entertaining cases. I know students like entertaining cases. I always got concerned it was so entertaining that the class discussion drifted away from the boring discussion of, hey, what are the elements of a duty to disclose under all that stuff, and floated more into, basically Ghostbusters and stuff like that. So I don't know, Steve, do you have any thoughts about this as a teaching case? Does it run the risk of it sort of not, doing its purpose?
Yeah, I think particularly for students, I don't think that danger exists with, say, lawyers can look at the case and probably use it a little more focused because it's not as surprising. But I do think it's fun. It might actually interest people who otherwise are not interested in disclosure, which I think is probably the danger that you're thinking about. Overly focusing on the fun parts of it, but as I found myself reading, I think, I don't remember, I think this might have been in the book that you used when I was in your contracts class, because I think we did talk about this case. And I remember now, like reading this thinking, gosh, I don't even know how useful this case is, because the holding in this case seems to be limited to when the seller actually creates this mythology around the house, and that strikes me as a fairly narrow scope and not really applicable to a lot of different ways that a fact pattern might come at a student or in the real world. It's ordinarily not the case that the seller is creating this. It's more likely that there's some latent defect that the buyer can't discover with reasonable care and just keeps their mouth shut, and this hurts the value. Now, this one's really interesting in some other ways to me, because this kind of raises the specter of
For those
see,
listening, not watching, I'm shaking my head. But yes,
yeah.
yes, continue, Justice Rubin. You're Justice Rubin's ghost.
I think I might be. Yes, that should have been my costume. But
It's not too late, Steve. Still coming up to Halloween. You walk around as a justice. Oh, what are you, Ruth Bader Ginsburg? I'm Justice Rubin. I'm a justice of puns.
I'll come around and pun you to death.
Yes, I will stay away.
Right, I'll make you groan.
Yes.
So this one I think is a little more interesting, and this could happen in the world, but this kind of raises the subjective objective issue with a defect, because this particular defect, a haunting, could very well enhance the value of the property. And so it does kind of bring this multidimensional potential for analysis if students can get beyond the fun and games of the ghosts.
You know what this would make? It would make a great essay question, because the students could have a lot of fun with it, and it's not just your boring, the wheat doesn't come on time or something like that. And I do agree with you that when you look underneath the surface of this case and get beyond sort of, the entertainment value of it, it's oozing with a lot of, and I don't think that was a Ghostbusters pun, right? It was oozing with, or was that slime? I've been slimed. It was slime.
Yeah, it was slime, but I was right there with the Ghostbusters too.
Thank you. It really is oozing with very interesting and very important issues involving a so-called duty to disclose, including, as you pointed out, that really narrow holding, something which I probably, when I was teaching, I overlooked, because I was using this case, I was trying to use it to demonstrate the duty to disclose. And it does have that narrowing aspect to it, which you're not going to see typically in most of your duty to disclose cases. Usually, I did not plant the termites there in my house because I like termites, and then write stories about how I have a house with termites. So, but let's set things up for students. So, and Steve, I know since you were a high school econ teacher and you think as, along economic lines. So we're dealing here with whether or not a party to a contract has some obligation to disclose to the other side information that the deal that the buyer, the other party, is about to enter into is not as good as they may think it is. And just from a general standpoint, and we're not talking about torts here. So Justice Rubin was pretty clear that although it looks like rescission is going to happen here, the court is not saying that this is tortious, that there is a tort duty to pay damages. It's just simply about whether or not the court will use its equitable power to allow this contract to be undone, to be rescinded. So this is a contract law case. This is not a tort case. Just in general, Steve, what are your thoughts about whether a party, I mean, as an econ teacher, former econ teacher, does it sort of surprise you to even think that there might be some sort of obligation or expectation for one party to disclose to the other party that they're not entering into as good a deal as they think they are?
I'm not surprised, because this is certainly an economic problem where markets get negatively affected by asymmetries in information. And to break that down, it means that one party has more information about the product or service or whatever the subject matter is than another party. And so where there's a difference in the level of information, for example, we take it for granted that we go and we pump our gas when our tanks are empty. We take for granted that we're getting 10 gallons of gas. There's no reason we know that. If there weren't requirements for inspections of those pumps and certifications by third parties to say, when this thing says 10 gallons have been pumped in your tank. If you as a buyer cannot trust that that's true, you're going to be reluctant to fuel up there because you have less information than the owner of the pump and the gas station. They possess the information as to whether their pumps work or not. You as a buyer do not. And so it does make sense to either have some sort of a third party inspection, which of course in this haunted house case, it seems not feasible that a third party could come in and verify whether this house is haunted, analogous to the gas station solution. And so I think what the courts have done here is quite rightly just forced or incentivized. They haven't forced, because you cannot disclose all day as long as you're willing to have your buyer back out of the deal. But so it's not really necessarily an affirmative duty here. It's more of, if you want to keep your buyer, I mean, you could keep trying to sell this house as is and not tell anybody and hope that the person who buys it is happy and doesn't want to rescind. But the court here, I think, makes the right call. Speaking of who you're going to call, and that call is to make the party who has is in the best position to know the haunted condition of the house, to in fact disclose it in order to even the information asymmetry so the market here can work. Because think about if the court went the other way, then the market would fail, because people would be more reluctant to seal the deal. And so this seems like a rule that makes markets more efficient for houses.
Yeah, I think there might be a tendency to believe that, well, economists would think that there's, shouldn't be some sort of duty to disclose. But economists, I assume, would want, for a well-functioning market, both parties to be fully informed. We want parties to enter into deals, contracts. The reason why we want them to enter into contracts is presumably because it'll make both parties better off. It is a win-win. I want what you have more than what I have, and vice versa. And if one party is lacking important information, that may not happen. And that's not good, because we're trying to get goods moved to their most valued users. And cases like this are interesting because you've got a situation where if the seller, as you've noted, possesses the information, and it is difficult for the buyer to figure it out, who you're going to call. I mean, there's not, I guess you could call some of these people who go around to houses and on TV and they figure out they're haunted, but that doesn't really exist. Then in that situation, the buyer would either be very reluctant, as you say, to pump the gas, or the buyer might, let's say it is possible to figure it out, but it's very hard. The buyer would then spend a lot of money, potentially be facing spending a lot of money to figure out the truth. I've got to check you out, figure out the house, do a bunch of research, because I'm scared to death that you're withholding information and there's no expectation that you disclose it to me. And if that cost exceeds, if it gets too large, at a certain point, I'm not going to enter into the deal. And if you could disclose, if you think of a case like this, how easy it is for you, Steve, if you are Helen Ackley, that cost you disclosing is zilch out. You just tell me, oh, by the way, here, read this Reader Digest. She's got like 50 copies. Here, read this Reader's Digest article. That's no cost to her, and compared to the cost to me. So it actually is saving money. But that's not always the way the law looked at it. And that's, of course, what makes this a great case, because we're seeing the erosion of something called the doctrine of caveat emptor. Buyer beware. We still have it, but there's been a lot of inroads on it and exceptions. I think, as Justice Rubin noted, they're considered what's unappetizing. A lot of these opinions that were based on caveat emptor. I think, Steve, in the old days, it was a time of much more of individualism. Like, take care of your, Steve, you know what you're asking for? You're asking for a handout. If you want me to tell you this house is haunted, disclose information for you. And I don't want to hear from you economists and your mumbo jumbo. When I grew up, Steve, we took care of ourselves. We're the latchkey kid era. We took care of ourselves. We looked out for ourselves. I didn't owe anybody anything, and they didn't owe anything to me. So do you think this old caveat emptor was sort of based upon that rugged individualism that was perhaps part of, what we stood for in this country early on?
Absolutely. I mean, if you took really, these are the descendants of people who survived in colonial times with very, very little but their own hands.
Sir George would be startled by this opinion. Like, what? And the Navy lieutenant? No one helped us? Well, I was just about to say no one helped us beat the British. I guess there were the French.
Yeah.
Yorktown and their
little revision, maybe. Yeah. But by and large, I mean, this was like a game of Survivor from a few centuries ago, and you make your alliances in order to survive. It's one of those things. But yeah, I think absolutely that's the heritage of caveat emptor and that personal responsibility. It's your problem. But then we sort of, I think, progress and realize, goodness, this puts a lot of unnecessary costs, because look at the opportunity cost involved is now I have to hire ghost inspectors.
Mm-hmm.
And that pulls resources out of the economy, because now you've got an industry of ghost inspecting.
Right. And not doing something else.
And not doing something else productive. And so this realization that, oh my gosh, this is creating inefficiencies and also clogging the market for housing. Now, Dan, here's something I don't know. Is caveat emptor more prevalent in the commercial real estate space, where parties are more sophisticated? Is this do you disclose business more along the lines of residential?
Yeah, so of course it depends on your jurisdiction. So, one of the challenges with contract law is that with 50 jurisdictions, you have 50 different contract laws. And particularly with caveat emptor, it's one of those things where you really do need to check your jurisdiction. And this is complicated because you both have the court system can be creating exceptions to caveat emptor, like we see with the Stambovsky versus Ackley case, a New York appellate case. And then you also have the legislature getting involved, because the sale of real estate is heavily regulated, and you have the legislatures often getting in. But in general, I'd say the answer to that is yes. In general, the duty to disclose is going to be greater when you're talking about, say, the sale of a residential home as opposed to commercial. But again, check your jurisdiction. And this raises a very important question, which is you say, well, is there a difference between commercial because people are sophisticated versus residential or not? The problem now arises is if let's say a court is going to they're going to start creating exceptions to caveat emptor. The question then becomes, well, what's going to be the exception? Where do we draw the line? Because, we go from this, I don't have to disclose anything to now I have to disclose something. And the problem with courts is courts tend not to be in the business of simply saying, well, okay, on these facts, you should disclose these. Next case, no. Although the common law system is very much, we take case by case. The courts, of course, also want to set precedent. They want to do rules of law. Otherwise, students wouldn't know what to write on the bar exam, right? So we gotta have rules of law. And so let's talk then about shift to, okay, what are most courts doing now that they're starting to erode from caveat emptor? What are most courts going to establish as the rule? And I wanted to just ask you one quick question before, I know you're the econ teacher and you never leaves, but before we officially, on this podcast say, okay, let's move away maybe from Steve Maxwell, the econ teacher. The one thing I think where I think courts are going to say I don't have to disclose, and I think the econ teacher and you would agree, is if I have acquired, I'm the seller, and I've made a lot of effort to acquire information. I'm sorry, the buyer. So work easier for the buyer. I've acquired a lot of information about an item you're selling. You don't know that you're selling a painting that's quite valuable. And I have done my research and I've worked really hard to figure out that it actually is valuable. And then I go on eBay or wherever and I scoop it up and I buy it at a bargain rate because you have no idea. Is it fair to say that the econ teacher in you would agree that for terms of the market and efficiency, I should not have to disclose to you that I know that you are selling something more valuable than you are?
Yeah, I think that's right. I absolutely think that's right because see that, and I know you're asking me not to talk econ here.
Well, no, you can now before you leave. No, this is your last
Okay.
chance. Get it out of you. Get it out.
Okay, because information is valuable. And so in the disclosure rule from the case, we're talking about information that was pretty much free to the seller because they created the information.
Right.
They
Or maybe
had
just came into it, or maybe like termites, they didn't do anything. They didn't know where either they create, they didn't incur any money like trying to find something valuable.
Right, exactly. And so in the unknowingly selling something valuable where the buyer has expended their scarce time and effort and maybe even expense to acquire the information, it does make sense for them to be able to keep the fruit of that expenditure of time and expense.
Because if you don't let me do that, then we're never going to discover that that's a Picasso, maybe, right? If there's not, right? If you don't reward people for figuring out it's a Picasso, people generally not going to spend the time figuring out it's Picasso because now it's a losing process. Basically, all we're doing now is you would be benefiting from my work. I figure out it's a Picasso. If I have to tell you it's a Picasso, now you're not going to sell it to me, you sell it to me for more. I just did all that work really for your benefit. And well, I'm just going to stop doing that. So, okay, well, let's talk about, so when should there be a duty to disclose? So if courts are generally going to agree that there probably shouldn't be a duty to disclose if one party has made a lot of effort to obtain valuable information that we want to encourage them to obtain, they shouldn't have to disclose that. But if I have casually acquired information, and this one is very odd. I mean, it is because we almost never talk about a party having generated the information, created the situation themselves. We usually talk about they've casually acquired the knowledge that they learn that there's termites because they see termites in their house, or they see roaches. I teach a case where there's a roach infestation. See, I can be fun too with my cases. Yeah. I replaced it with goodies, the other
You-
good cases. It's kind of
You're a
hobby.
blast, Dan. You
Yeah.
don't have to work hard to do that.
Yes, yeah, I mean, that's a horror story to have your house infested with roaches.
Absolutely.
So usually, courts are going to say that there tends to be an obligation to disclose in contract law when the defect is, number one, typically something that is significant, material, important. And let me talk a little bit about where the restatement of law, restatement of contracts situates this so-called duty to disclose. And we do know that quote phrase duty to disclose is a bit misleading because, as you pointed out, no one is being sued for damages typically here. It's just enabling that party to rescind the contract if the other party didn't disclose. We tend to throw around that word duty pretty broadly just because it's very, well, what else are we going to say?
Yeah.
We don't really have a good word or place. So I'm going to call it a duty to disclose, as long as we all understand that we're not talking about a duty to pay damages. If you don't, there's no civil liability. It's just rescission of the contract, which is a pretty important point because rescission of the contract is a so-called equitable remedy. And an equitable remedy, the courts are going to have more discretion to do things out of fairness. And so when Justice Rubin here talks about, well, under tort claim for damages, he doesn't have a ghost of a chance. When I'm moved by the spirit of equity, the jokes aside, it's an important point because he's saying, look, I'm just being asked here whether this contract can be undone. That's an equitable remedy, and that can be based much more on fairness notions, a lot more flexibility for the court. So the restatement second of contracts says that if you should have disclosed it and you didn't, then there's actually a misrepresentation. Most people, I think, view it as, well, a misrepresentation is something affirmative. Are there any ghosts here? No. You've made an affirmative misrepresentation.
Right. There's no representation at all, let alone a misrepresentation.
That is exactly the way most people think about it. The restatement says if there was an obligation to disclose, we're going to treat it as a misrepresentation. If you didn't disclose something you should have. I actually like this only because I think then it situates it with all the other elements and requirements for misrepresentation. But so keep in mind that you're a professor. So in law school, they may view this as the restatement does, and they would expect you to talk about it as, well, if there's a non-disclosure and you should have disclosed, it's a misrepresentation. Others may not. They may view it as separately and look at you kind of weird if you talk about a non-disclosure as a misrepresentation. They may say, well, how can there be a misrepresentation? Steve, as you put it, there's not even a representation. So just be aware of that treatment of this doctrine under the restatement. Okay, so this is what the restatement says. The restatement says okay, Steve, I know you're a lover of rules, not a lover of standards. So you're going to love this. Ready for this?
I'm ready.
You ready? You have a duty to disclose. It's going to be horrific. You have a duty to disclose when good faith and fair dealing would say that you should disclose. Now
that's so clear,
isn't it? Now, let me point something out to make things even more confusing. This is not the implied covenant of good faith and fair dealing. So wait, you just said good faith and I heard you. Rewind. No. I did not say that. I did not say it is the implied covenant of good faith and fair dealing. The implied covenant of good faith and fair dealing can only arise upon contract formation because it is a term of the deal. So when the restatement is talking about, well, there would be a duty to disclose if it would, let me just read it. non-disclosure would, in the circumstances, constitute the failure to act in good faith and in accordance with reasonable standards of fair dealing. It's not saying you've breached the covenant. You've not breached a contract by not disclosing because you don't have a contract yet. But it is still that same phrase being taken by the restatement and being used to help Steve give you this amazing guidance on when there should be an obligation to disclose. So how you feeling knowing that's the standard? How you feeling?
Clear as mud, very confused. Now, I'll tell you, one of those confusing points to me is, on these facts of this case, I think we had a contract, right? So that the contract had been formed, and this suit arose between the contract and the closing, because the closing had not happened yet. The deposit had been put down, and the buyer was trying to get the deposit back and get the court's blessing to back out of closing. Am I right on that?
Oh, you're absolutely correct. Though keep in mind, the argument is that the contract that I was induced to enter into this contract by your failure to disclose. So the non-disclosure occurs prior to contract formation. It induces me to enter into the contract. The trap is sprung, contract formed, and now I want to undo it because I said your failure to disclose in negotiations was a failure to act in accordance with good faith and fair dealing. And so I should be able to unspring the trap.
Gotcha. So how is that? Now that's different from during the performance of the contract, the obligation of good faith and fair dealing. So that obligation arises after formation.
That is correct. Well, I think Article 2 in a comment, I think has some sort of example and suggestion otherwise, but restatement law, general contract law, correct. Because think about it. It is a covenant. Covenant is just a fancy word for promise. It is a term of the deal. And you can't have a term of the deal until the contract forms. So yeah, the implied covenant of good faith and fair dealing is when the party during performance or enforcement of the contract does something that we think is shady, that they shouldn't be doing. So that's the dividing line here. The fact that this is a non-disclosure prior to contract formation, which is the alleged bad behavior, is what makes this a case of, I want to undo this based on non-disclosure. Good faith should require you to disclose it, but it's not a breach. You're not alleging a breach of the contract. Implied covenant of good faith and fair dealing is a term of the contract. A breach of that is a breach of the contract. There's no alleged breach of the contract here. Buyer's not alleging a breach of the contract. The buyer is alleging that they were induced to enter into it based upon a non-disclosure.
I got you now. So it's like this non-disclosure doctrine sort of borrows from that good faith and fair dealing and takes a little smidge of it and puts it prior to formation with respect to non-disclosure of latent defects.
So anytime, I think when we think you shouldn't be doing stuff, but we really don't know how to define what you shouldn't be doing,
we make up a rule or an exception.
And good faith and fair dealing is a great one.
Yeah.
It's a very serviceable phrase, right? I'm like, this is what we want. What shouldn't you do? What you have to disclose? I don't know. You just be good, So I think it's just a very serviceable phrase. When we can't, we don't want to be more specific. We can't be more specific. What did they say? Was a Potter Stewart about, pornography or obscenity? I know it when I see it. Which apparently led to when they would watch these films in the basement of the Supreme Court. Apparently, I don't know if you've heard this. I think it was in the book, The Brethren. Some of the justices then would yell something like, "There it is!" So it's a little bit of that, I'll know it when I see it.
And I think these things are more prone to happen when equity gets involved. I mean, the courts can bend over all kinds of different ways, no pun intended there, to just make the right outcome. Like this is a values-based decision when it comes to equitable relief.
That's absolutely true. So, equity comes from the old English Court of Chancery. And I know anytime on a podcast about contract law starts kind of on a scale of interest between 0 and 10, you're lucky if you're starting at a 2. And I know the minute you say Court of Chancery, you automatically get a -1 and it's dropped. So we're in very danger here. But yes, the Court of Chancery is the Old English Court of Equity. And you go to the Court of Chancery when the courts of law weren't helping you out. And so it was sort of like, hey, give me a break, would you? Help me out. The courts of law are tough as nails. They're so rules oriented. And so when you hear equity, we still live with this today. When you hear a remedy in equity, we're generally talking about a remedy that the court is going to be given because he thinks it's the fair thing to do, the just thing to do. It's like you have law. See, there's nothing about justice on the law side. It's all about rules, I guess, right? No justice there. And then equity, you think of it more justice. So that's, and I'm glad you asked about that because it does sort of now, when you go in and you read Stambovsky versus Ackley, and you just see a word equity, and law students will be like, okay, fairness. But Justice Rubin is really saying something when he says that. When he says, look, I am moved by the spirit of equity, he's not kidding. That's a very serious statement because what he's saying is, I think that my equitable powers are going to allow this court to let this buyer out. Whereas on the law side, and we don't have, just about everywhere doesn't have separate courts of law and equity anymore. But what he's saying is, since rescission is an equitable remedy, I'm taking the spirit of the old Chancery Court, and they would be much more inclined to look at the fairness of it. So let's talk about, and that's why good faith and fair dealing does make sense, perhaps, in this rescission doctrine.
Well,
all right.
Can I ask a question here? Because this jumps us back over to law. If this case had arisen after he bought the property, after closing, and now he's suing the seller for misrepresentation or something of that nature, trying to get damages, does the buyer here have a problem because we can't appraise the diminution of value in the home after he buys it? Is this a damages problem? Is this the reason we're looking at this case from a pre-closing perspective?
Oh, so that's a very interesting question. So, well, the damages issue and the valuation, I think, remains an issue. We'll talk about that. Assuming that he's suing for damages, and the problem with the damages is, there's probably not a tort duty disclosed. I think Justice Rubin is pretty clear about that. There's no tort claim here. Now, you could make it a breach of contract claim. There could be a warranty. I mean, we just make up some fact, right? Hey, is this house haunted? No, it's not. And let's say that's a warranty claim. Let's assume that warranty has not been discharged by the parole evidence rule, right? Because there might be a writing then with a disclosure, with a disclaimer clause and a merger clause. Let's assume that there's now a representation as part of the contract that it's not haunted. And he's now suing. Sometimes you don't want rescission. I mean, I talk about this, like you buy a horse and the horse has been warranted to you as in sound condition. And you get the horse and the horse is lame. Now, you could ask for rescission, but come on, Steve, what's happened to you? You and that horse, tell me about this story.
You bonded with that horse.
Yes, you're right. This poor guy, he's lame. They made it, if you rescinded, the buyer, the seller may just be like, well, I'm going to take it and shoot it. Well, no, don't shoot Lucky. Right? No. So sometimes you don't want rescission. You like the house. You're unhappy it's haunted, but you still like the house. You just want damages.
You get along with Sir George. He's a great conversationalist.
That's actually, you jest. But is this not going to be something important, perhaps, as to whether or not this is something that needed to be disclosed? Is this something significant? These ghosts seem pretty awesome. they call them a poltergeist. I don't know the legal definition of poltergeist, but this is not poltergeist from the movie, right? Where it was horrible. This seems to me like this is a bonus that you get woken up in the morning.
Right.
So
You don't even have to chase. You don't have to wake your daughter up. You just let the ghost raise the child. This is like a fantastic nanny.
Does this ghost drive? So we had this debate, my wife and I, it wasn't much of a debate about whether we should get a car for our daughter when she turns 16. And it sounds all very sort of I don't know, does it say bougie? Bourgeois? I don't know, is that what are the kids saying?
Yep,
now?
I think so.
But you're not hip with the kids anymore either. You're 80s.
I'm very chuggy, as they say now. I think.
What is it?
Chuggy.
I can't even pronounce that.
Oh yeah. Chuggy is like the new term for like old people that try to be cool.
Oh, I'm a chuggy.
You are a chuggy. You're not a chuggy. I think maybe we'll get emails. We'll get hate mail about this.
Yeah, post in the comments, please.
Yeah.
So we had this discussion, because it seemed like kind of like, yeah, I get my daughter a car when she's 16. And my wife was like, no, are you kidding me? When I grew up, blah, blah, blah. When I was 18, I finally got a clunker, blah, blah, blah. And I'm like, no, I do the driving. I drive her to school every morning. She's getting a car. I've been driving for 16 years for around. You're getting a car. But so it seems, so let's talk about so if there had been a suit for damages, the valuation issue, the plaintiff is entitled on a warranty claim to the difference between the value of the goods as they are versus the value they would have been had they been as they had been represented. So you're entitled, this is going to remind you of the Harry Hand case. You're entitled to the difference between the value of a house that is haunted, what you have, and a house that is not haunted. And so if you gotten that warranty, then you would be entitled to that difference. And I don't know how you value it. I mean, I have to tell you, in all honesty, Steve, I don't think it's that hard to value. My guess is that you could get real estate agents in there as experts to testify on on how they're probably all they know, I've seen it all. Like you probably say to a real estate agent, hey, so, and you think you're being all funny. Hey, so if a house is haunted, yeah, like how much does that hurt the value? Ha, ha, ha. And they're like, okay, so, well, what area are you talking about? Because some areas people are less concerned about it. Generally, the more liberal areas, people tend to be okay with ghosts. The more conservative neighborhoods, tell me about the upper class people, the lower class. So my guess is that they could probably give you valuation. I don't know. And remember, you only have to prove the difference probably to at a reasonable certainty, not to an absolute certainty.
But I think that you run the risk if you're the buyer in that situation, suing for damages. You might be at risk for this house being more valuable, haunted, than not haunted. Because it's a thing. People want a haunted house. Some people do, and so I think in a suit for damages, you do run that risk that maybe like that more objective valuation comes out against you and that the house is actually more valuable when you truly don't subjectively want the house anymore. And so that's why I thought this was a good illustration of equity being more concerned with the individual buyer's situation than a suit for damages, then going and doing a more objective valuation of the property.
Well, that's right. And when we get to damages in future podcasts, we'll talk about the probable damages is that they are guesstimates. They're rare. Sometimes they're spot on, hey, you promised me $2,000. But even then, interest rates are like, is it really an accurate representation of the time value of money for you? We tend to just be estimating, and we tend not to award damages for emotional disturbance in contracts, right? As you famously, at least for me, famously said, there's no crying in contracts. And so the market value, like you said, is an objective measurement. If you sold it, well, what if you want to stay and you're bothered by ghosts? And everyone else is like, why do you have a problem with ghosts? They're awesome. These ghosts are so nice. they wake up your kid in the morning, but you're like, yeah, but it freaks me out and I can't sleep. And I'm always bothered. I'm always concerned that instead of waking up my kid, they're gonna like attack the kid. And that gets hard to value. Number one, you generally don't get it. It's very hard to get emotional disturbance damages. And even if you do get it, it's very hard to put an objective measurement on, well, very impossible to put an objective measure on it. And so you do run the risk with damages of either overcompensation, now the plaintiff's happy, defendant's unhappy, or undercompensation, plaintiff is unhappy, defendant's happy. And so you may not want to run that risk of undercompensation. You just want to say, look, I want out. And that's what rescission does. So let's talk about what generally courts will say. When is it a failure to act in accordance with good faith and fair dealing to not disclose? And just to note, this is not the only situation in which there is a so-called duty to disclose. The other ones, though, are a little bit, they're the ones that we tend not to talk a lot about. It's like I said something at the time that was true when it was made and before contract formation. I know it's no longer true. Like, hey, our business is doing great. During negotiations before formation, I know our business tanks. I'm expected to tell you. I know that you are acting under a mistake in the writing. I'm supposed to tell you. Or if this one's a little bit more common, relationship of trust and confidence. You're my brother, and I'm selling you some land. I have an obligation to tell you what I know about the land, even if ordinarily I wouldn't to a stranger. But this is the bigger one, the good faith and fair dealing. So typically courts are only going to require a disclosure. And when I say that, I'm trying to emphasize that this tends to be unusual. So students should start with this idea that in general, a party does not have an obligation to disclose information to the other side. And again, we're talking about common law. What are judges doing? If the legislature has come in and passed a statute that requires disclosure, well, then of course that applies. The legislature can always override the common law. And my guess is from the article you sent me, right, and the student of yours that sent to you from the ABA Journal talks about there's a lot of states have a lot of statutes, but that's generally not what we're talking about. In contract law, we're talking about the common law. So under the common law, though it's a little weird to call it common law if it's equity, but okay, let's not go there, because then it really does go to a zero. So first off, typically we expect it to be something significant, important. Does that make sense to you, Steve, that a seller should not have the obligation, and this is any type of contract, it's not just a house contract, but this still tends to come up in house contracts. Does it make sense that I shouldn't have to disclose to you all the little things that might be wrong with the house? And let's make clear what's going on here. Steve, I know the microwave doesn't work. I know it doesn't work, and I don't tell you. And you're walking by the microwave, and I'm watching you, and I'm hoping you don't say, does the microwave work? You don't decide to like, hey, can I have a cup of tea? Sure. And I don't say anything. I'm clearly being bad. But do you realize why I shouldn't have an obligation? Or does that make sense to you? That I should have to tell you about all these little things.
Yeah, absolutely. Because to not require materiality would then open the door to any flaw, non-disclosed, leading a buyer to be able to get out of the deal. And let's face it, every single piece of property has some sort of flaw. And so like you can pick as small as you want, but it just essentially makes contract formation a nullity if the buyer can just point to some scuff mark that allows them to get out of the deal.
It reminds me a little bit is of Jacob and Young's v. Kent. It was a substantial performance / material breach doctrine where, I build this big mansion for you, and instead of using Reading pipe, I use co-host pipe, and the owner doesn't want to make that final payment. And Justice Cardozo says, make the final payment. That in building a mansion, there's going to be some deviation from the specifications, probably. It's just going to happen. And if you allowed a party not to perform their end of the deal because of a minor defect, people are going to be getting out of paying and performing all the time. it just sort of reminds me of that. So yeah, so the first thing is it needs to be important. So let's talk about that, because that remains I think that remains an issue. It's all a little unclear to me in this opinion. You know, it sounds like Justice Rubin is saying, look, there's going to be rescission. At one point in time, he says that this case is clearly warrants a grant of equitable relief to the buyer. But then he also notes how this is on a motion to dismiss. And for students who are also taking civil procedure, they should recognize that that doesn't necessarily mean on a motion to dismiss, you know, that just means that you're arguing the plaintiff's complaint doesn't state a claim for relief. It doesn't mean that you're resolving whether or not the plaintiff is going to win. And Justice Rubin actually says the extent of this impairment may be presumed for the purpose of reviewing the disposition of this motion to dismiss the cause of action for rescission and represents merely an issue of fact for resolution at trial. So it sounds to me like maybe the issue of, is this something significant, maybe is still in play. I don't think it is, because everything seems to be, Rubin really seems to be suggesting this is not in play. But let's talk about this, because it does need to be something significant. So if you were writing on a law school essay, Steve, so you get this as your fact pattern, should the student be talking about whether or not this is a so-called material defect?
I think absolutely, because this is such a fuzzy standard, like everything, like good faith and fair dealing. Any of those fuzzy standards are just screaming at you to argue both sides of this, because, this haunting, could be a good thing, could be a bad thing. Maybe this isn't even a defect for some. So materiality and defect, I think, go together in my essay here if I'm writing this. And I would argue the heck out of, this is a material defect and this is not a material defect, because if you're one of those students who reads this fact pattern and says, oh my God, that's scary, and you quit thinking about it, and you only see one side, ask yourself, can I see another side to this? Question that confidence, as I'm sure you would if you saw a ghost. You're like, do I really see that ghost? Am I losing it? And actually think through the problem for both sides.
And am I really seeing a ghost brings up something we haven't mentioned, which is probably the most famous part of this case, which is that Justice Rubin says that the house is haunted as a matter of law. He makes a statement that as a matter of law, the house is haunted, which of course, in many respects, is the most entertaining part of it. Justice Rubin obviously knew what he was doing. He had to have had a twinkle in his eye when he wrote that. So Justice Rubin says, since the defendant, Ms. Ackley, had in the past represented that this house was haunted in the Reader's Digest article, in the walking tour, that she could not both represent that it was haunted, use that to her advantage in the past, and then change her position on that fact. Estoppel, particularly like an equitable estoppel, is when you say X and then in litigation you try to say Y. Usually you have to have reliance by the other party on that first representation. You don't have that here. It's not like they were aware of the Reader's Digest article or anything like that in the past. But estoppel tends to be when a party is trying to take inconsistent positions and the court thinks it's unfair to do that. And so if you are estopped from denying the truth of your prior assertion, then the truth of that assertion is presumed to be established as a matter of law. It's not real. It's just it's a conclusive presumption at this point. But it's funny, is it not? Because it makes it sound like Justice Rubin is declaring this house to, in fact, be haunted.
It kind of reminds me a little bit, not to jump holidays here, but Miracle on 34th Street, when the post office is delivering letters to Kris Kringle. And he says, well, the post office, the United States government has declared you to be Santa Claus. That's what this is reminding me of.
That is perfect. That is exactly right. That's exactly right. So we'll have to do a Christmas special, and then we'll do that. We'll talk about that trial, I guess, right?
That'd be a good one.
Yes, I remember that one. So we'll do that one. So we've already got our holiday special ready to go. So proving Santa exists. So though it's really more for, I guess, for an evidence class. So yes, I think you should have a counter argument here, that on an essay you'd have a counter argument. And I typically would talk about this in class. Is it significant? Is it not significant? And this is where some of the things that Justice Rubin talks about, which are entertaining, are quite important. He talks about who you're going to call. So if the house is haunted, is this different? If the house now, as a matter of law, is haunted, and we know also what's significant too is here, the reputation of the house being haunted is a problem too. Whether if the house is haunted or it has a reputation of being haunted, how do you dispel that? And I think that's where his "who you're going to call" comment comes from. Who are you going to call, Steve? Right? I mean, is this different from termites? Is this different from roaches?
Yeah, in that respect, yes. But that's one of the reasons why I think this opinion didn't sort of go far enough and limited it to this idea where the seller had created the condition in the first place. And I guess that's one of the problems I have with this opinion, is that it's not the standard non-disclosure language in their holding.
Yeah, so let's talk about that as well. The court emphasizes that the seller had created this condition and then had taken advantage of it. And this particularly pulled at the equitable heartstrings. So law has like keeping with our holiday theme, the Grinch's little heart. What is the Grinch's little heart? And then it like expands. So the little heart is law, the law side. The big one that pops out is the equity side. And the fact that the seller had actually taken advantage of this, and now created this idea, and now is trying to take it, not disclose it, suggested to the court that there was greater equitable reason here to rescind it. So I'm going to both defend and not defend Rubin on this. Number one, we're dealing with caveat emptor and not a rolling back of it, but a limiting of it. And that's a big deal. So this was a big deal. This is way beyond, in theory, this is way beyond just a haunting case. This is the appellate court of New York is announcing that there are going to be inroads and exceptions to the caveat emptor doctrine. That's a big move. That's why the dissent, Justice Smith, is very bothered by that. Justice Smith is like, seriously? You're gonna create an exception with this case? Let's deal with a case where there's a real problem, not a nonsense, is this house haunted case. Let's wait for a true defect in the house if we're going to decide to create an exception. So that's why he's so bothered by it. But the court does limit it there. I think in some respects I agree with that, because you shouldn't, you should really have the right case. So it's a little bit of Smith and dissent. You should have the right case to create a big exception, a big defined exception. The rule, if it's going to be if this case speaks for an exception because of its particular facts, is it a little bit dangerous to draft it more broadly? Does it become more dictum-like to do it more broadly? And in some respects, is Justice Rubin, well, you may not like it because you teach for the bar exam. I may not like it because I'm teaching contract students for the bar exam and general contract law. But for the law of New York and exception to caveat emptor, can one make an argument that Justice Rubin is right to limit it as he does to the facts?
Yeah, no, I definitely see that point. And it does make you wonder, would termites pull at the heartstrings any less? You know, like to me, no, but it makes sense in the historical development of this exception to caveat emptor.
So we've got, so I think for purposes for students studying for the bar, students who are taking a contracts exam, this limitation that we see in Stambovsky is generally not one that we see, where there's only going to be a duty to disclose if the seller created the situation. Most of our cases are not like that, right? I didn't create the termites. I didn't create the roaches unless I was, a really messy, eater and stuff like that, leaving my food around. I didn't create these problems typically. That's not a requirement, but it does have to be something significant. And so you would have the fight here over, I think anyway, you'd have some argument, counter argument over how significant is this? But the court does seem to think that even if it is not actually haunted, the mere fact that it has a reputation for being haunted is likely going to affect the market value enough that they consider this an important defect. So buyer's not there yet though. So that's sort of the first thing. You got to have something that is important that wasn't disclosed. The second thing is typically that it had to be something that was difficult for the buyer to discover. And I think this is interesting, Steve, because what this means is that if it's obvious and you don't see it as the buyer, and I know you didn't see, like, wow, you say to your spouse, oh my God, I can't believe I didn't look in there. They didn't just, it's so obvious. I can't believe it. They didn't look up and see that enormous crack in the ceiling. There's this huge crack running down the ceiling. So
the big chalk outline of a body in the living room.
Exactly
they just totally blew right past it.
Right, the yellow tape. They didn't ask about like all those investigators over there, like those cops in the corner with the chalk mark and the yellow tape. And they didn't ask why there's like, there's like a hearse outside and there's like, So what that means is apparently, what I love about this, Steve, is that we are still part individualistic, right? About things that we're not letting completely go on this idea that you should take care of yourself. So the law, court of equity, law of equity, seems like, look, I'll meet you halfway, but only halfway. You still got to do the basics. We expect you to gauge your own reasonable efforts to investigate. We're not going to save you if it was something that was, say, obvious or through reasonable efforts you could have discovered. And so that also can create a lot of interesting essay questions, as I don't know what it means to be, that a reasonable person should have been able to discover it, and due diligence would have discovered it. That's very debatable. But interestingly enough, the more obvious it is, the less of a duty I have to disclose to you, even when I know or have reason to believe that you've missed it and haven't seen it. Now that's on you. So in other words, it's worse. The only thing we don't like, the only thing we like worse than the person who hasn't disclosed and has been a bad guy not disclosing it is we don't like the person who should have seen it and didn't, or should have discovered it through reasonable efforts. We like that person less. We hold them more blameworthy in certain respect than the guy who knew and didn't tell.
It's true, but I can think of ways, and I wonder if, these just haven't made it through the courts yet. Maybe they have, but say I'm vision impaired and I'm a buyer and I can't see the crack in the ceiling or the chalk outline on the floor. What then? Is this is this latent to a reasonable person that, is the reasonable person visually gifted? Who is this person?
Yeah, I don't know the answer. Usually I think of it, typically in contract law, it is just the so-called reasonable person or the average person. And we don't add, and that person typically, we know that person might not be able to see necessarily, but that person, the reasonable person who can't see, gets somebody to inspect it for them. At least what I'm talking about, I don't know on your specific question. When I say inspect it, I was actually thinking about inspect the contract. Remember our duty to read rule, which is that even if you are blind and you sign a contract without reading it, that's blame, you're held blameworthy for that because you should have found somebody to read it to you. So my guess is, just speculating here, is that, courts might say, look, it's same thing here. You knew you couldn't see, so you're expected to bring somebody along with you. I don't become your keeper, so to speak. Now, as the seller, you need to find somebody to do it for you. So I could easily see the court saying that. So, so now the big question is, is this something that we think that the buyer should have discovered, particularly Stambovsky versus Ackley, the haunting, or the mere fact that it had a reputation for being haunted? Is this the kind of thing that we would call, as you refer to, a latent defect, which is a defect which is sort of, latent means, under the surface, something hard to discover, versus a patent defect, which is something that is easy to discover. And, the line between patent and latent is surely fuzzy at times. And we know that there's a rule in non-disclosure, similar to non-disclosure. It's called concealment, which the court in Stambovsky talks about. Concealment is a little different. You might view a failure to disclose as a type of concealment. You're concealing facts. But in contract law, the doctrine of concealment refers to active concealment. I actually paint over the crack before you come to inspect. I put the plant and the pot in front of the crack, though that's what we're talking about when we're talking about the law of concealment. So this isn't concealment. You've got affirmative misrepresentations. You got something called a half-truth. You've got concealment, which is active concealment, and then you've got this, which is non-disclosure. So would this be hard to discover, Steve, do you think, in Stambovsky, or is this the kind of defect, assuming it is a defect, so we've moved on, let's assume the court has concluded this is something significant, that it is either haunted or has a reputation of being haunted. Would you consider this in the category of latent defect or patent defect?
I think you've hit upon a great point, that this is, again, majorly arguable. If the ghosts are there 24/7, 365.
It's basically, it's like well, I don't know if it was a library, and the library, it was in New York City, when the Manhattan Library, the one with the lions, was that the one in Ghostbusters, I think?
Yes, it was.
That was pretty bad. I mean, when they're called, wasn't he just like this big, slime ghost just sitting there, like?
Yeah, and then there was a female librarian that was hovering, and reading books, and
people running out. I can't remember. Yeah. People running out.
But she's like, shh, because they're over there talking. But if it's that, if that's the ghost and they're just out there hovering all the time, then I think that's a patent defect. But if the ghost,
I'm sorry, like the movie Poltergeist too, right? That would be. Right, wasn't the movie Poltergeist was crazy, wasn't it? I can't remember. Or did she just disappear?
But aren't all those ghosts in movies, aren't they like disappeared and then they appear sometimes? Mm-hmm. Like if they were there all the time, like get a life. Oh wait, maybe they lost that.
I need the dun.
Yeah, you do.
Yeah.
But I think our notion of ghosts is that they show up some of the time, at least. And even in this case, I think that's an argument, is that for a latent defect, that, hey, ghosts, our popular notion of ghosts is that they only show up at night, or in this, when they're trying to scare you. And so they are latent defects because they're not always there. I don't go and inspect this house at 2 a.m. when the ghosts are out. I inspect at noon, when my lunch break, when I go and take a tour of the place.
It reminds me, I teach this case I think it was out in New Jersey, where the roach infestation case, and the roaches would only come out at night. And that's a song too, isn't it? She only comes out at night.
Yes.
Oh, we got it again. Is this the man-eater again? I think we talked about man-eater.
Oh, what is that song?
It's right, man-eater, right? So they inspected it at night. They didn't mean to inspect it at night. They stopped by the house in the evening hours to do something or whatever, and they turn on the light and there's roaches everywhere. But so you're right, this buyer is not going to really have an opportunity to discover these ghosts. He's not living there. I agree with you. Ghosts, they pop in, they pop out. And I mean, there's only been like so many sightings of this ghost over years. And also emphasized here too, and let's talk about the reputation of haunting though. So that's a more serious issue, is whether or not this buyer, through due diligence, maybe by going down to the public records office, should have discovered or maybe going down to the slaughtered lamb inn or whatever down the street, should have discovered the reputation of it being haunted. Maybe they should have gone, picked up that Reader's Digest that is sitting on the table at the dentist office in Nyack, New York. But here's the problem, and the court points this out: he's from New York City. He's not a local. So, Steve, does that seem to be something important here? That, because you asked, well, who's the reasonable person? Doesn't it seem to be that the court is saying, well, the reasonable person at least has the attributes of where you personally are from. You're the reasonable person from New York City. You're not the reasonable person from Nyack, New York.
Yeah, and I think it's doubly important here because we are talking equity, and it's clearly something that this buyer could not have discovered, unless they just happenstance picked up a Reader's Digest somewhere.
Yeah, or I mean, I guess they come there and they could have asked around about the house, but would that have been weird? So they could have gone, if everyone in the neighborhood knows, there's been walking to it, people are going to know, right? Oh yeah, that house, right? They probably call it the haunted house. So
right, but this, let me go back to economics here for a second, because how many transaction costs do we want to put on the buyer? Do they have to go and interview neighbors? Like, that seems very costly and cumbersome. If you check the public records, you have the inspector out, you do the things that are reasonable and can be done from New York City or anywhere to try to keep commerce flowing and keep the sale of homes efficient. But then to require a buyer to go and do a personal investigation and interviews and explorations and get every subscription to any magazine, now you're talking really clogging the market for homes. And I think the court is very aware of that in the background.
Yeah, and why would you even be doing that? Because you're only doing that if you think there might be something that couldn't be discovered with all those other things you talked about, like a termite, the typical inspectors. You would have to be thinking there's actually something about this house that wouldn't be discovered through those typical means that the neighbors would know about. And that's just odd. I mean, who thinks about that, right? I mean, who thinks about canvassing the neighbors about what's happened at the house? Just like you said, like, it's a lot of effort. And what are you actually likely to discover? I mean, it's so weird. What's interesting to me, though, is that the more we have a market for certain inspectors, not Ghostbusters, we don't have that yet, but we do have for termite inspections, which probably long ago, right, didn't happen. The more you get a market for it, does now the prudent person, are they expected to make use of that? So is a lot of what is prudent driven by how much has this been happening, and has a market arisen? The more that you hear stories about, let's say that you start hearing more and more stories about hauntings. So it really is Ghostbusters, where the level of paranormal activity is rising just throughout the country. And oh my gosh, 20% of all houses are now reportedly haunted. Now you wonder, does the prudent person start looking into it? So this, don't you think this can be a fluid thing? It's something that it's not static, something that was not prudent to look into, as time changes, arguably could become prudent. Is that fair to say?
Absolutely. Like, if, asbestos being used in drywall and ceiling insulation, that sort of thing, back in the 70s, 60s, and you're buying a house from those decades, I think yes. I think that's a standard that can evolve based on there it is, information available, and that's the key, I think, here to making the market work efficiently, and that's why the court chooses a standard that can evolve with the flow of information.
Indeed, and we know the court here is of the opinion that the majority is of the opinion that this is not the kind of thing that a prudent person would have discovered. he's not a local, and how are you going to figure out this information? You're not. So I want to talk about one last thing I think was very interesting about this case, and that is that there was essentially a disclaimer clause and a merger clause that basically the buyer was disclaiming any reliance on misrepresentations by the seller, and that it was disclaiming representations to the physical condition of the premises and quote, any other matter or things affecting or relating to the aforesaid premises. Now, assuming that we consider a non-disclosure as a type of misrepresentation, this is becoming quite serious then, because the argument is that the buyer has agreed that they're not relying on any misrepresentations. There might be also an as-is clause where the buyer is buying the premises as is. The court here is going to say this language that there was this merger clause, or we'll talk more about merger clauses, the parole evidence rule. Typically, when I think of misrepresentation, I think of a disclaimer clause. Merger clause is merging all outside promises and agreements, in saying everything that we agreed upon, all the terms of our deal are in this writing. I think of a disclaimer clause as disclaiming any reliance on representations. Disclaimer clauses tend to fit better with what we're talking about with misrepresentations. But the court is here going to say, even though there's been a disclaimer of any representations concerning any other matter or things affecting or relating to the premises, which ordinarily, if you've disclaimed, you're not going to win on your rescission case because you're agreeing to assume the risk. And the court's you're not pulling on the heartstrings anymore if you went into this understanding that you're assuming the risk. But the court says that it does not believe this clause, this disclaimer clause, sufficiently covers what is happening here. It says that it doesn't view it as, it views it as relating to the physical premises, and that it does not believe that this is tangible or physical, and therefore it doesn't cover here a normal phenomenon. And anyway, even if it did, then the seller's in trouble because they represented that the property was vacant and then it wasn't vacant. So you kind of can't have it both ways. What do you think about that, Steve? We see here a court not wanting to read a disclaimer clause too broadly and sort of reading it in a very narrow way, it seems to me, because it thinks maybe it's the fair thing to do.
Yeah, I think the court just said, this isn't fair. Let's come up with a reason to not enforce this and allow the buyer to back out. And they just sort of bent over backwards to do it. And this strikes me as one of those harsh form contracts that just is included in every single sale contract. And the court's calling BS on it and saying, no, we're not going to stand by you pulling this one on your buyer.
You're absolutely right. And I'm glad you referred to, sort of the standard form contract. And this is probably boilerplate language. And there's a New York case, and they cite to a very famous case out of New York called Dannon Realty Court versus Harris, where the New York, a very influential case beyond just New York, dealing with whether or not disclaimer clauses are going to defeat rescission claims. And the New York Court of Appeals held that when you have a broad general disclaimer clause, a boilerplate clause that just says buyer is disclaiming any reliance on any representations made by seller that are not included in the writing, period. It just stops. That generally those are not going to be given much respect. They're generally not going to be enforced, particularly when the buyer is not sophisticated. You asked about that. Particularly when the buyer is not very sophisticated. It's a boilerplate clause. The courts are generally not going to say it trumps a rescission claim. Whereas if it is a specific disclaimer clause, so it specifically says buyer disclaims any reliance upon the past amount of business any that has been made by the seller, if it's a commercial transaction, that's generally going to be much more likely to be given effect because the parties have thought about it. You're very much on alert that, okay, you're disclaiming any representation on this particular type of thing, particularly if you're sophisticated parties, it'll much more likely be given effect. So what I think is interesting about this is it goes to show that disclaimer clauses are not necessarily just your parents' interpretation. It's very much, when you're talking about rescission and equity, even whether or not a clause, a disclaimer clause, is going to be given effect, is going to be infected with the spirit of equity. And well, yeah, okay, maybe it says it, but it's all very broad and very boilerplate, and we're not going to allow it to trump versus, oh, it's very specific. We think you thought about it. Did you read it? That actually can matter here. And so here the court says, give me a break. It seems to be just a broad clause. It talks about the physical parts of the property and other matters, but we just don't think that is specific enough to deal with this situation, something paranormal, which of course you're never going to get there. Are you, Steve? Sans, and you're not relying upon any representations we're making about whether's haunted or not. Sans that, I don't think you're ever going to get a disclaimer clause that covers this. And so,
and that, just the fact that you've got that disclaimer clause in the contract should put the buyer on notice. It's kind of like, hey, I definitely didn't hide the body over there. It performs that function.
And it's perfect. And you're absolutely right, because actually that's what it's supposed to do, right? The court almost with this treatment disclaimer clauses seems to be saying, we're not going to let you get away with it. So you can disclaim, but yes, the mere fact that your disclaimer is sort of putting the other side on notice, that's the point, isn't it? Mm-hmm. It's not, the seller thinks this is terrible, but the court is almost like, no, it's not terrible. That's exactly what's supposed to be going on. If there's no duty to disclose, or if there is a duty to disclose, if you want to get rid of that, you're basically going to have to alert the other side that there's a possibility that I'm not disclosing something to you I should be disclosing to you. And so, yes, that's the mere fact that it's like, oh my gosh, well, wait, I'm now hinting to them that there's a body over there. The court's like, exactly. We want it that obvious that you're basically hinting to them that maybe they should be asking more questions and not entering into this contract. That's really what a disclaimer clause is supposed to do. It's not supposed to trick you into waiving your right of rescission. It's supposed to put you on notice to maybe ask more questions.
And I like what you said. If there's a duty to disclose, we really can't give effect to disclaimers that don't disclose.
Yeah, that's exactly right. The disclaimer clause, that's exactly right. So you start with, is there a duty to disclose? If there's no duty to disclose, we're done, as long as you didn't make an affirmative misrepresentation. Hey, is this haunted? No. So we're done. Then let's say we decide there would be a duty to disclose because typically it is something that is latent, be difficult for the buyer to discover, and we think it's something significant. Then it's a yes, but then you go back to there is no duty to disclose. If the parties are agreeing, they're basically opting out of the duty to disclose rule by having this disclaimer clause. But think about it. If the court is going to allow the parties to opt out of a duty to disclose, that's a big deal to say there's a duty to disclose. It's something latent and it's something significant. Hey, if we're going to create an exception to caveat emptor, we generally don't want you to mess with it too much, right? I mean, we'll let you mess with it, but we've spent all this time building this exception. If the parties are going to agree to opt out of the duty to disclose, we want to make sure that before that happens, they mess with our beautiful creation, that both parties, particularly the buyer, really does understand. They really now should have been aware that their parties were opting out of the duty to disclose. And the boilerplate clause, particularly with an unsophisticated party, we're not feeling it. Not with the spirit of equity, does not feel it. So
right, we're almost possessed with equity here today.
We are. It's the haunted halls of Chancery. So sounds like a great movie, doesn't it?
It does.
A book maybe.
That almost seems like a misleading representation when you're going to watch that movie. It almost seems like a duty to disclose that, hey, we're really talking contracts, so prepare, get your pillow ready.
Yeah, this movie's terrible. What? I thought this was going to be like a ghost story. It's about the development of the Court of Chancery and how it's haunted by the rules of equity and the maxims of equity. This movie stinks. All
My
right.
doctor prescribed this for insomnia.
Exactly. Or this podcast. So if anyone, so for those, Steve, any concluding thought for anyone who is still awake and who doesn't feel like they should listen to this because they're a law student, for anyone still awake, any final thought on the wonderful case of Stambovsky versus Ackley?
Only to say, make sure you go down to the bottom here under the video and click on the ABA Journal article. I think it's a fine read. It really kind of takes some of the theoretical of this particular case and makes it concrete to fairly common today issues with non-disclosure. And I think it's a great read.
Because on your bar exam essay or your law school essay, it's probably not as interesting. Let's face it, it's probably like the sale of a deli, right?
Yeah, I think that's right. Yes.
And on that depressing note, that concludes this Halloween Squibcast special of K-Talk. Hope you enjoyed it. We will see you next time.